All right, we are right at 2 o'clock and there are a good amount of you in here. Welcome to our webinar that is a joint host between TJS Deemer Dana and BNY Mellon. We have a great presentation planned for you. We're excited to hear from Jere. But first, I just kind of wanted to go over a few things. So as in the past, you guys are more than welcome to use our Q&A feature at the bottom. If you have any questions throughout, and then at the end of the presentation or as he sees fits, Jere will go back and answer a lot of those questions. If your question does not get answered, we will share their contact information at the end, and there will also be a follow-up email after this webinar concludes as well. So make sure you use the Q&A feature, and if you have any questions after, we will follow up on that. And then right now I am going to introduce Hunter Groten, also works in the Atlanta office of BNY Mellon. He is their senior director, and he is going to introduce us to our speaker today.
Thank you, Brittany. Again, I'm Hunter Groten from Atlanta, but proud to be broadcasting live from the TJS Deemer Dana offices in Savannah. Just to give you a moment of background, BNY Mellon is the oldest private bank and most experienced fiduciary in America, which dates back to the time of our founder, Alexander Hamilton. At BNY Mellon, we see wealth management as a three-legged stool: investment management, private banking, and estate planning. If any one of those three legs are out of balance, the stool tips over. So everyone understands the importance of investment management, or good performance, good investment performance, that is. But oftentimes people overlook the power of sophisticated private banking or coordinated estate planning. After all, it's what you have after taxes and what you're able to pass on to your heirs that matters the most. As the world's largest global custodian with over $37 trillion under management, we're considered to be the safest bank in America. And as you can imagine, we are blessed with great resources. Well, today you'll hear from one of our finest estate planning resources named Jere Doyle. He is a nationally recognized expert on tax and estate planning, and he's one of the American Institute of CPA's most sought after speakers. TJS Deemer Dana's interest in hosting today's webinar demonstrates their great interest in their clients and being on the cutting edge of today's estate planning knowledge. So it certainly underscores their interest in your well-being, and we appreciate having the opportunity to have Jere participate. So here is Jere. Thank you.
Ready to roll? Welcome, everybody. Good afternoon. What we're going to do this afternoon is we're going to go through the basics of estate planning. And when I say basics, I mean the basics. If anybody has any questions, even if they're sophisticated questions that you want to ask as we go through this, feel free to ask any question, even if it's not something we talked about today, because most likely I'll be able to answer that. So here's what we're going to do. We're going to go through this agenda. We're going to talk about what happens if you don't have a will. We're going to talk about writing a will, what assets are subject to probate. We're going to talk about probate and non-probate assets, and then we'll talk about the problems that you'll have with probate. And I'll explain what the probate process is as we go through. We'll talk about whether or not titling assets as joint tenants with rights of survivorship is a way to avoid probate. We'll also talk about the fact that, just simply having a will is not enough. You should have an estate plan. We'll talk about what that consists of. Basically, that would be a so-called pour-over will. I'll explain what that is when we get to it. We'll talk about a trust, the different types of trust, being one that is a testamentary versus an in vivos trust, and I'll explain what those are. We'll go through a typical estate plan so you can see what it looks like, and I'll explain the tax ramifications of it. And then finally, we'll talk about an irrevocable life insurance trust, and I don't think I'll confuse everybody with generation skipping trust. So we'll end most likely at an irrevocable life insurance trust. And that basically what that deals with is how you can get life insurance proceeds to be excluded from your estate for estate tax purposes. So a lot of people in the United States actually do not have a will. They have not written a will. And so the question is, what happens if I don't write a will? And I've always said, well, if you don't write a will, the state has one for you. And that is in the form of the state intestacy statute. When you die intestate, you're deemed to die without a will. If you die testate, that means you have a will. So if you don't have a will, there's a state statute that basically tells you where your assets are going to go. And each state is a little bit different, but basically what will happen is if you have a surviving spouse, your surviving spouse will get somewhere between 1/3 and 1/2 of the assets. You and your kids will get the balance of the assets. And it all depends on who you leave behind, whether you leave a spouse, kids, no spouse, no kids. If you have brothers and sisters, parents, etc., the statute covers every one of those situations. For example, in Georgia, I believe that if you die with a will, die without a will, and you have a spouse and you have children, they share the estate, but the spouse, the surviving spouse, has to get 1/3 of the estate. So, for example, if you died with $300,000, the surviving spouse would get $100,000, and the kids would split the other $200,000. The important point about writing a will is not only it allows you to dispose of the assets the way you want, as opposed to having to rely on the state statute, it also allows you to choose an executor or an administrator, somebody who is going to basically act as your representative and settle your estate. And if you have minor kids, it allows you to name who you want to be the guardian of those kids in the event that you die while those kids are minors. And more importantly, if you were thinking about doing any tax planning, you don't write a will, you might as well forget about it, because the milk is spilt. There's nothing you can do really post-death as far as any type of sophisticated tax planning. So what you'd want to do is you want to write a will. Now, what you've got to understand is that a will is only going to control the disposition of probate assets. And I'll explain what that is in just a second. Other type of assets, non-probate assets, they are not governed by your will. They'll pass in another way. We'll talk about that in just a second. So only probate assets are governed by the terms of your will. The disposition of other type of assets that are not considered probate assets are going to pass otherwise by other types of documents. We'll explain what that is in just a second. So let's talk about the probate process. What happens with probate and why do we have probate? Let's suppose somebody dies and let's say they either have or they don't have a will, but let's assume they have a will. What's going to happen is whoever is appointed as the administrator or the executor of that will file a petition with the local court. In my state of Massachusetts, it's the probate court. They'll file a petition with the court asking the court to appoint whoever is named in the will as the administrator or the executor of that will. For example, there's a guy that lived down the street from my parents and he just died. He was 101 years old. Family wants to sell the house. Well, the house in his estate is a probate asset. Before anybody can do anything with that house, they've got to go into the probate court, file a petition, and get somebody named as the executor of that will in order to be able to act with his property, be able to sell the property. So once you file the petition, after a certain period of time, notice is given to various parties, the heirs, creditors, etc. The court will appoint somebody to act as that representative. And what are their duties? Well, what they've got to do is they have got to file an inventory with the court of all the probate assets. And again, I'll define what probate assets are in just a second. So you file an inventory, and then what they do is they collect the income that the estate is earning. Maybe that decedent had some stocks and bonds that are paying interest and dividends, or maybe they had some other type of money coming in. So they'll account for the assets that come in, and they'll pay the debts and the expenses. And so what will happen is after they have basically settled the estate, they have collected the money, and they have paid the debts and expenses, they will distribute the remaining assets to the beneficiaries under the will, and they will have to file an accounting with the probate court, telling the court what you started out with, what came in for money, what went out in expenses, and what is left over with the beneficiaries. And that's basically how probate works. And the reason for probate is basically so assets that a decedent leaves does not end up going in a direction to somebody other than the person or people that the decedent wanted to leave those assets to. And I'll give you an example. My dad, who's now, he's 96 years old. He practiced law for a long, long time. And probably about 25 years ago, he had a client and he was named as executor of the estate. The client died in February. And the client lived down by the beach. Now I live about 4 miles from the Atlantic Ocean. And so the beach is fairly nearby. But during the wintertime, the beach is pretty seasonal. So people are down there like from now until probably October. But after that, the beach basically at nighttime looks like North Korea. There's not a light on the whole beach. Well, this particular person lived down the beach. The decedent lived down the beach. It was a woman. And my dad said to me, when I got home from work, he says, let's take a ride down the beach. And we'll, so-and-so died. We're going to go down and take a look and see what the family is doing in the house, because he knew it was going to happen. So we get down to the beach, we park across the street, and every light in the house is on. And we could look in the windows. And at this point, obviously, the person just died that day. My dad had not been appointed as the executor of the estate. The family members are rifling through the drawers and the closets and everything. My dad knew that this particular woman had a bunch of loose diamonds, whether, I guess she traded in diamonds or something like that. And she also had a 3/4 length mink jacket. And as we sat across the street, we watched the family members go through the drawers and everything in the closets looking for assets. And, we knew it was going to happen, that there were going to be assets that disappeared. Well, that's why you have probate. So those assets don't disappear. Somebody can secure those assets and can make sure they go to the right beneficiaries. And in this case, the diamonds, my dad knew she had diamonds because she had told him. And he also knew that she had this 3/4 length mink jacket because every time in the wintertime when she came into his office, she'd wear the mink jacket. Well, when he got appointed as executor, he never found the diamonds and he never found the mink jacket until another person that we knew died. And we went to their funeral mass, and one of this other woman that had the diamonds, one of her best friends, is walking back from communion, and she's got the decedent's 3/4 length mink jacket on. It just kind of disappeared. It didn't go to the woman that the decedent wanted it to go to. So we have the state basically acting as big brother to make sure the assets that you leave in your will go to the right beneficiary and somebody doesn't, who's not authorized, doesn't take them. So that's why we have the probate process. So let's talk about what assets are subject to probate. Probate assets, the ones that are governed by your will, are those assets that are held in the decedent's name alone. They're held in your name. So for example, if I own Bank of New York Mellon stock in my name and I die, in order for that stock to get from me, let's say I leave it to my wife, it will have to go through probate. Somebody will have to go and file the petition to be appointed as executor of my estate. They'll have to file an inventory showing that Bank of New York Mellon stock. They'll show the dividends from the Mellon stock coming in. Then eventually an account will be filed and the executor can distribute the Mellon stock to my wife. So probate assets are assets that are in the decedent's name alone. Non-probate assets are assets like that are in joint tenancy with rights of survivorship, meaning that if my wife and I own that Bank of New York Mellon stock as joint tenants with rights of survivorship, the minute I die, by operation of law, my half of those assets goes over to my surviving spouse. So now automatically at the moment of death, she owns 100% of those assets. That's what we mean by with rights of survivorship. When I die, she takes over the assets. There is no need for probate in that situation because the assets by operation of statute are automatically going to go to my surviving spouse. And that applies to any assets that's held as joint tenants with rights of survivorship. So I could hold a house, for example, in joint tenants with rights of survivorship with my brother. I die, he gets my half, he owns 100%. Also, any assets that are transferred via a contractual arrangement. For example, if you have life insurance, The life insurance will pass to whomever you name as the beneficiary on the beneficiary designation form. And the same thing with an individual retirement account or a 401k plan. Whoever you name on that beneficiary designation form is going to get that asset. There's no need to probate those assets, because if the life insurance company pays the wrong beneficiary or the IRA custodian pays the wrong beneficiary, guess what? They've got to pay the right beneficiary. So they may end up paying the proceeds twice if they end up paying to the wrong beneficiary. So there's no need for the state to protect those types of assets. So joint tenancy assets, any asset that passes by a contract, like life insurance or retirement plan benefits, or you may have a payable on death account, those don't need probate because they're automatically going to go to somebody, either the person that's named as a beneficiary in the beneficiary designation form, or they're going to pass by operation of law. So just think of probate assets as the assets that are in your name alone. That's the easiest way to think about it. Now, there are disadvantages to probate, and there's basically four. It's going to cost you money, and it's going to depend upon the state that you're in. In Georgia, you do have limitations on the amount that the administrator can charge. In Massachusetts, where I am, it's whatever the market will bear. And typically in Massachusetts, you're looking at 2 to 8% in fees to administer a probate estate. In my state, it will take you 18 months to 36 months to get through probate. Some states are quicker. They say it's some states say it's more efficient. I'm not really sure I believe that. The court has supervision over the whole probate process, because probate is a court procedure. So the court basically is overseeing the whole probate administration. And I can tell you that the probate courts in my state are not that efficient. I actually waited for over a year to get a hearing recently on a trust in the probate court in Massachusetts. And then finally, we had to do it virtually. It was kind of a nightmare. And more importantly, the thing people don't realize is that your will is a public record, as well as the inventory that the executor files, as well as the accounts that the executor files. So anybody can walk in off the street into the probate court, fill out a form with your docket number, and get your file that has your will, your inventory, and your account, and take a look at it. And I'll give you an example of how that would work. Probably about maybe 25 years ago, I had to do this program. And I was thinking, how can I illustrate to people that probate is public record? And I was sitting at my desk in Boston. I thought to myself, hey, I'm gonna run across the street to the Suffolk County Probate Court and see if I can get a copy of President Kennedy's will. Kennedy was a resident of Massachusetts when he was assassinated. So at lunchtime, I went over to the probate court, I found his docket number in the index, filled out a form, handed it to the clerk at the probate court. He looked at it. Obviously, he recognized the docket number. And he said, what do you want this for? And I said, well, it's public record. I have a right to see it. So he goes into the back room and he comes out with a stack about this big of pre-Xeroxed John F. Kennedy wills on 8.5 by 14-inch paper, complete with the red wax seal on it. And he gave me a copy. So I took it home and, I read his will. I got to go in the probate court and get a copy of the President of the United States' last will and testament. And when I was doing this program, I actually used that example of, and when I did this program, it was probably 20, 25 years ago. And I used this example of how I could go in and get the president's copy of the president's will. And after I was doing the program, a woman came up to me and she said, gee, my kids and I were always interested in how Jack passed his estate. And I said, did you know the president? And she goes, oh, let me introduce myself. I'm Joan Kennedy, Ted Kennedy's ex-wife. And so she said, can I have a copy of the will? And I said, sure. So I gave her a copy of the will that I had. She says, oh, my kids are going to love this. We always are trying to figure out what happened with his estate. It wasn't that difficult, but I just thought it was interesting. So the message is, you go through probate, it's public record. If you want to avoid that, I'm going to tell you how to do that in just a second. So we know that assets that are held in joint tenancy will not be a probate asset, and you will not have to probate those assets. So people think, okay, here's what I'll do. If I put all my assets in the joint name of me and my wife, then when I die, there's no probate, right? That's right. There's no probate because the assets that I have, title and joint tenancy, are automatically going to pass to my surviving spouse by operational law. So they're not going to be subject to probate. However, what's going to happen is when my surviving spouse dies, when my wife subsequently dies, what's going to happen? She owns the assets 100% in her own name, unless she's transferred them prior to the time she died. And let's assume that she hasn't. So I die, she owns 100% of the assets in her own name. She got them from me. They passed by operational law. Therefore, those assets at her subsequent death now become probate assets, unless she's done something before she died to make them a non-probate asset. So generally speaking, joint tenancy is a poor substitute for a will, because at the subsequent death, the second spouse's death, or the second joint tenant's death, those assets are going to be subject to probate. And the other thing you have to worry about is what happens if, for example, my wife takes my assets by operational law and she becomes incompetent during her lifetime. She can't deal with her assets. Now what's she going to do? We're going to have to go in and get either a conservator or a guardian appointed in the probate court, and bingo, we're back into the court system again, and we want to avoid that. So how can we do that? Basically, what we're going to do is, instead of just simply creating a will, we want to create a comprehensive estate plan. And your basic package for an estate plan is going to consist of, one, a will, and what that will say is basically, I leave, my tangible personal property to whomever, most likely my spouse, and then all the rest, resident remainder, I leave to a trust, a so-called revocable or revocable trust, however you want to pronounce that word. So I'm going to have a will, and I'm going to have a trust, two separate documents. And what's going to happen is any assets that are probate assets after I die are going to be distributed by the residuary clause in my will that says all the residue goes into the trust. So eventually they'll end up into the trust. And what we really want to do, and I'm going to explain this in just a second, is before we die, we want to transfer those assets into the trust. Because if the assets are transferred into the trust during our lifetime, who owns the assets? The title is in the name of the trustee, and you can be your own trustee of the trust. Since the title is in the name of the trustee, they're not in your name alone. Therefore, the assets that you transfer into the trust are not probate assets at your death. So you can avoid probate by funding a revocable or a living trust during your lifetime. Just simply transfer the assets into the trustee's name. And as I mentioned, you can be the trustee. You don't like the trust at some point in the future, you can rip it up and get the assets back, or you can amend the trust, whatever you'd like to do. So a funded revocable trust during your lifetime is a way to avoid probate. The other thing you want to have is a durable power of attorney. And that could not be more important than in the current environment we're in right now with the pandemic. You got to think about people. They may be in the hospital, they may be on a ventilator, et cetera, and they can't act on their own behalf. Somebody's going to have to pay the bills. Somebody's going to have to cash their dividend checks and things like that. Somebody who is appointed as an attorney, in fact, under your durable power of attorney, can act on your behalf. So a durable power of attorney is part of our basic estate plan, as is some type of a healthcare directive, or what some people refer to as a pull the plug type of an instrument. And, in a lot of cases, you might want to go back, if you have one, some type of a healthcare directive or a living will, you might want to go back and look at that now, because a lot of standard language prior to the COVID basically had language that said, there should be no extraordinary methods taken to preserve my life. I don't want to be on a ventilator, et cetera, things like that. Well, think about how a lot of people's lives are being saved right now that have contacted COVID. They go on a ventilator, and your healthcare directive may say, I don't want to go on a ventilator. That could save your life. So things that we put in those healthcare or living wills in the past might need to be changed right now. You might want to go back and look at your living will or your healthcare directive, if in fact you do have one right now. So Basically, our durable power of attorney, as I mentioned, gives somebody the ability to act on your behalf if you become incapacitated. And the magic words that make that durable, meaning that somebody can act on your behalf, is it says, this power of attorney shall not be affected by my subsequent disability or the incapacity of the principal. Normally, a regular power of attorney, once you become incompetent, is no longer valid. But if you have that magic language in there, if you become incapacitated for some reason, your attorney, in fact, can still act pursuant to that durable power of attorney. So that's part of our basic estate plan. We have 4 documents. We have a will, a trust, a living trust, we have a durable power of attorney, and we have a healthcare proxy. So our pourable will, basically what our will is going to look like is it's basically going to say, okay, I leave my tangible personal property to somebody, household effects, your automobiles, etc. And then it's going to name somebody to be the executor of estate, name a guardian for any minor children that you have, may have some other boilerplate provisions in it. But if you do have probate assets, what that will is going to do is it's going to have a residuary clause. It's going to leave the residue of your estate to your revocable trust. So your revocable trust will really be the dispositive instrument, the instrument that's going to dispose of your assets. And that revocable trust is private. It's not subject to probate. So for example, you can leave your property to whomever you want, and the public will never know. And a perfect example of that is John Lennon. John Lennon, when he died, he had a funded revocable trust. Nobody knows for sure, except for John Lennon and whoever received that property. Nobody knows where his assets went. Now, you know, as a practical matter, we all know it went to Yoko Ono, but you're not going to find the document that says that, because his revocable trust is a private agreement between him, his trustee, and the beneficiary. It's not filed in the probate court. It is not public record like a will is. So we can have 2 types of trust. We can have a testamentary trust, or we can have a living trust. And the difference between the 2 are this. Your testamentary trust is contained in your will itself. So your will may say, I leave the tangible personal property to my spouse, and everything else, I set up a trust under my will. So testamentary basically means the trust is set up in your will and takes effect at your death. So the actual trust provisions of a testamentary trust are in the last will and testament itself. It doesn't avoid probate, because in order to get those assets that are in the will into the trust, they have to go through probate first. Compare that with a living trust. It takes effect during your lifetime. So you can transfer assets into a revocable trust right now. And as I said, you could be named as a trustee of your own revocable trust. And you will basically won't have a problem if you become incompetent, because there'll be provisions in that living trust as to how to handle those assets in the event you become incompetent. And when you die, the assets in that trust will not be subject to probate, because again, those assets in that funded revocable trust are non-probate assets. The trust itself is really kind of like a contract between you, your beneficiary, and your trustee. And as I said earlier, assets that pass pursuant to a contract are not subject to probate. So what is a trust? Basically, it's a contract between you, the trustee, and the beneficiary, indicating how you want your property to be disposed of. Testamentary and a living trust will both help control the disposition of your property, but the benefit of a living trust is, as I said down the bottom there, the bottom right-hand box, if you have transferred your assets into that living trust or revocable trust during your lifetime, those assets are not probate assets. They avoid probate. So they avoid the 4 disadvantages of probate: the cost, the delay, the privacy, and the court supervision. All of that stuff is avoided. And if you become incompetent during your lifetime, all of the problems with an incompetency are avoided as well. So most people that have, you know, and you don't have to be a multimillionaire to have a revocable trust. A lot of people that have, you know, under a couple $100,000 will have a revocable trust, so they'll avoid probate. Probate is a pain in the neck that is easily avoidable by funding a living trust. And you're not, if you put assets in a living trust, it's like transferring assets to the right, from the right pocket to the left pocket. You don't lose any control. You can revoke the trust at any point in time. And like I said a couple of times earlier, you can be the trustee of your own living trust. So an unfunded trust, not going to avoid probate. We're going to have those assets that pass under the will eventually will end up into the trust, but they got to go through probate first. And as I mentioned, if you put the assets, title the assets in the trustee's name during your lifetime, you're in this living trust, you're going to avoid probate, and you can operate the trust during your lifetime. The assets, it's simple. It's kind of like having a bank account. At the end of the year, you get a 1099 from the bank telling you how much interest you earn. With a funded trust at the end of the year, the trustee will furnish you a statement showing you how much interest, dividends, rents, or whatever have been earned in that trust, and you simply report that in your income tax return. And the funded trust can receive assets from your probate estate after you die. So in a lot of cases, people say, should I put all my assets in the funded living trust? And I usually say, no, you may want to have a checking account in your own name. You don't want to be going to the grocery store and try to cash a check, to the extent people still use checks, try to cash a check and the check says, the Jere Doyle, trustee of the Jere Doyle Revocable Trust, and the cashier goes, what's all this about? So you may want to have some assets in your own name. If that happens and you die, those assets are probate assets, but your residuary clause in your will eventually pass them into the trust, into your living trust, where they'll be disposed of. But ideally, would like to get as many assets as we can into our living trust during lifetime to avoid having to go through probate. Like I said, if you don't get anything out of this, probate's a pain in the neck. Probate is easily avoidable. So basically, I just explained what a trust is. I'm not going to go through that again, but let's take a look at, let's step it up a little bit and show you what a funding living trust looks like. Now we've got poll question number 1 up there. So people, this is just to make sure everybody is still awake, still paying attention. We're going to have 4 polling questions that are going to pop up at various times during the presentation. So there's polling question number 1, and that will disappear. Now, step it up a little bit. We're going to talk about a basic estate plan that most sophisticated people use. They have, the top box represents your estate, that is your will. And underneath that, you're going to have a separate trust, that is your revocable living trust. So you've got 2 entities. You're going to have a will and you're going to have a trust. So there's 2 separate documents that have to be drafted. Now that living trust at your death, this is the basic estate plan that most people use. When all the dust settles, this is the way it looks. Your living trust after you die, if you're married, is going to split into 2 shares. One share called the marital trust and the other trust called the exemption trust. Now here's what this is all about. Right now in the United States, each person has an exemption from estate, gift, and generation skipping tax of a whopping $11,700,000. So unless your estate is worth more than $11,700,000, you will not be subject to federal estate tax. Now the Biden administration and Bernie Sanders would like to reduce that exemption from $11.7 million down to $3.5 million for estate tax purposes and as low as $1 million for gift tax purposes. So on the plate for the administration is reducing the current $11.7 million exemption down to $3.5 million for estate taxes, $1 million for gift taxes. And that's why a lot of people are trying to hustle up to use their exemption now before the exemption goes away. But let's suppose, just for illustration purposes, prior to 2010, the exemption was $1 million. The estate and gift tax exemption was $1 million. It's now $11.7 million. Let's assume, for purposes of illustration, the exemption is $1 million, and your estate is worth $5 million. Now, the planning was this. We know that we've got an exemption from estate tax, and we know that if we take advantage of that exemption, whatever assets will eat up that exemption will not be subject to federal estate tax. And we can structure our estate so the amount of that exemption will never be subject to tax either in my estate or in my surviving spouse's estate. So let's say I have an estate of $5 million, and let's just assume that the current exemption is $1 million. What my living trust would say is it would say, transfer into the exemption trust the amount of my exemption, which is $1 million. And it would say, transfer everything else in my living trust that's left over after you transfer the $1 million exemption into that exemption trust, transfer that over into the marital trust for the benefit of my spouse. So what will happen is at my death, the first death, the amount of assets that are in that marital trust will qualify for the federal estate tax marital deduction. Whatever I give to my spouse is not subject to federal estate tax. So the assets that go into that marital trust are for the benefit of my spouse, qualifies for an estate tax marital deduction, are not taxed. The $1 million that goes into my exemption trust at my death, the first death, that's going to qualify for the exemption. So that's not going to be subject to tax. At my surviving spouse's death, here's what's going to happen. At my surviving spouse's death, the assets in the marital trust are going to be included in my surviving spouse's estate for estate tax purposes. So let's just suppose that $4 million didn't appreciate at all. There's $4 million left when my surviving spouse dies. That $4 million is included in her estate for federal estate tax purposes. So eventually what we've done is we have deferred the estate tax on the assets that go into the marital trust until the surviving spouse's death. They're not subject to estate tax at my death because it qualifies for the estate tax marital deduction. This is on the left side of the screen, but they are subject to estate tax when my wife dies. In return for the government giving us the ability to defer the tax on assets that are left to my surviving spouse, they make me pay, or they make my surviving spouse pay tax on it when she subsequently dies. What about the exemption trust? The exemption trust, when my surviving spouse dies, at my death, those assets in that trust were not subject to tax because we put $1 million in there. That's the amount of the exemption. And therefore, they weren't subject to tax at my death. And at my wife's subsequent death, that exemption trust has given her limited rights in that trust. And limited rights means that you can't, the government can't tax those assets. So at the second death, I have structured that exemption trust in such a way that my surviving spouse has limited control over that, meaning that the assets in that exemption trust are not subject to federal estate tax at the time that she dies, when she subsequently dies. So look what happens. The assets in that exemption trust are never subject to tax. So let's suppose we take that $1 million in the exemption trust when we fund it when I die, and we swing for the fence and we invest that exemption trust aggressively so that when I die, when my wife dies, that trust is worth $4 million. How much is included in her estate? Nothing, because we have structured that exemption trust in such a way that she has limited control over it. She may be getting income from the trust, but she has no rights over the corpus of the trust. So she has limited rights over the corpus of the trust. Like maybe the trustee has the right to distribute money to her in the trustee's discretion. That means that because she has limited rights, when she dies, not subject to tax in her estate. So whatever assets are in that exemption trust when my surviving spouse dies are not subject to federal estate tax. So we defer the tax to the second death in the marital trust, and we totally avoid the estate tax on the assets in the exemption trust. Now we've got $11.7 million exemption. If somebody had, let's call it $12 million, had a $20 million estate, you'd have 12 million in the exemption trust and the remaining 8 in the marital deduction trust, and the same thing would work the same way. So that's the way our exemption, our marital trust and our exemption trust works for estate tax purposes. Now, what I've done here on these next few slides, and again, another polling question. Just, you know, I just submitted a program to a group in Minnesota, a group of CPAs in Minnesota I have to speak at next month. And I had to put polling questions in there. So one of the polling questions that I put in to the trust was, which of the following people played for the Boston Celtics, the Boston Bruins, and the Boston Red Sox? So I had 4 individuals, 4 choices. So who played for the Red Sox, the Celtics, and the Bruins? And so the selections I had, like, I had Ted Williams, Chuck Connors, John Kiley, and I forget who the 4th one was. Well, it's a trick question. The person who played for all 3 teams is John Kiley. He played the organ in Fenway Park, and he also played the organ at the old Boston Garden. So people think you're actually playing the sport. No, he was playing the organ in Fenway and in the old Boston Garden. Trick question, but it's a great trivia sports question if you ever want to trip up somebody in a bar. Bet him a beer in a bar. So here's the powers that you can have over the exemption trust. The income can either be mandatory or discretionary. As far as principal, the surviving spouse could either have no rights, discretionary principal, principal for health, education, and maintenance and support. That's an ascertainable standard. They could get the greater of $5,000 or 5% of the trust corpus, or they could have what we refer to as a special power of appointment. We won't go into that. So this just illustrates the limited powers that the spouse would have over the exemption trust that would cause that trust not to be taxable in the surviving spouse's estate. Now, with a marital deduction, how do you qualify? You can leave it outright to your spouse. You can also get the estate tax marital deduction by leaving it into a trust where she gets the income for life, and she has what we refer to as a general power of appointment. She can appoint to anybody. She can appoint that property to anybody she wants, including take it all out for herself. That's what a special power, a general power of appointment is. And in the another form is a qualified terminable interest property trust, or a so-called Q-tip trust, where the spouse has to get the net income, and she either has no rights over principal, discretionary, principal for health, education, maintenance, and support, et cetera. So this just shows you the various different powers that the trust, that the surviving spouse can have in each one of the trusts. The most important thing is, if the trust is going to be for the benefit of the surviving spouse, in order to qualify for the marital deduction, the surviving spouse has to get the income every single year, and nobody else can get any amount out of that trust during the surviving spouse's lifetime. That is a requirement in order to get the estate tax marital deduction for the for any trust that's going to leave assets to the surviving spouse. Now, last thing we'll talk about is irrevocable life insurance trust. Let's suppose you have a life insurance policy. When you die, let's say the policy is worth $1 million. When you die, those policy proceeds, or that policy matures, and the $1 million in life insurance proceeds get paid to your beneficiary. Well, for federal estate tax purposes, life insurance is subject to federal estate tax if it is payable to your estate, or if you, as the insured, have so-called incidents of ownership in the policy. And by incidents of ownership, what we mean is you have some type of control over the policy. You can change the beneficiary on the policy. You can borrow from the policy. You can surrender the policy. You could pledge the policy. If you have some incidents of ownership or control over the policy, that's going to be included in the insurance proceeds are going to be included in your estate for federal estate tax purposes. But insurance is a very easy asset to get excluded from your federal estate for estate tax purposes. And what you can do is you set up an irrevocable life insurance trust. So here's the process that you're going to go through. I got this illustrated here. You're going to go, and this is a 4-step process that has to be followed in this order. You go to your attorney. The attorney drafts an irrevocable life insurance trust. Step number 1, get the trust drafted. Step number 2, you know you want to buy insurance inside that trust, but the trust is empty. So you as the grantor are going to transfer some money into that trust, at least enough money to pay the premiums on the life insurance policy. And this could be a situation where you transfer that money in each and every year. I know I just did this for a client every year for the last 20 years. They've sent a premium roughly $20 million on a $1 million second to die life insurance policy. I got the check from the grantor last week of an amount to put into that trust. I put the money into the trust, and then that would be step number 2 when you originally set this up, transfer the money into the trust. Step number 3, you as trustee, whoever the trustee is, goes to the insurance company, buys the insurance policy. The owner and the beneficiary of the insurance policy is that irrevocable trust. So what the trustee does is the trustee takes the money that is in the trust, has been added to the trust, writes a check to the insurance company for the amount of the premium, and the irrevocable life insurance trust is the owner and the beneficiary of that life insurance policy. The grantor, the person who set this up, has never got his hands on the insurance policy, doesn't have any control over the insurance policy. And obviously the grantor is not the trustee of the trust. So what's going to happen in this case, when the grantor or the insured dies, the insurance proceeds come into the irrevocable life insurance trust, and they are not subject to federal estate tax because the grantor, the insured, has never had any type of ownership or control over the policy. And therefore, the insurance proceeds can be distributed to the beneficiaries free of federal estate tax. So the result is the life insurance proceeds are not included in the insured's gross estate for federal estate tax purposes. Now, what you don't want to do is this. You don't want to have buy a policy in your own name and then transfer the policy into an irrevocable life insurance trust, because if you do that, there's a 3-year look-back period or 3-year inclusion period. If you transfer an already owned insurance policy into the irrevocable trust, you have to wait 3 years before the policy proceeds are not subject to federal estate tax. So in order to avoid the federal estate tax, follow the 4-step process. Draft the trust. After you draft the trust, put money into the trust. 3rd step, trustee uses the money to pay the premiums on the life insurance policy that the trust owns and is the beneficiary of. And then when the decedent dies, the insured dies, those policy proceeds are not included in the grantor's gross estate for federal estate tax purposes. And I said I wasn't going to cover generation skipping trust. Well, I lied. We'll cover it pretty quickly. Generation skipping trust, basically, if you transfer assets from you to somebody who is 2 or more generations below you, there's a special tax called a generation skipping tax. So think of it this way. If I transferred property to my grandchildren, which I don't have any yet, but if I had grandchildren and I transferred property to them, that property would be subject to a generation skipping tax. So what a lot of people do is they will set up a generation skipping trust. Well, the exemption for generation skipping tax purposes is the same $11.7 million exemption that we have for gift and estate tax purposes. So I could transfer up to $11.7 million gift tax free into an irrevocable trust. The assets in that trust grow for the benefit of my children, grandchildren, etc. The amount that goes into the trust would be sheltered by the $11.7 million gift tax exemption. Since I transferred the assets into that trust during my lifetime, they won't be in my estate for estate tax purposes because I don't own them anymore. The trust does. And then finally, when distributions are made to grandchildren, that $11.7 million exemption will exempt that entire trust from generation skipping tax, even if that trust grows to be 20 or $30 million. So basically, these are called dynasty trusts because they can establish a fund for the family that continues on for generations. So that basically was a generation skipping trust is. So with that, I am basically done. I see a polling question in the chat. Other than that, if we have any questions, I'm looking to see if any questions. Oh, we have no open questions. So I will turn it back to either Hunter or Brittany. And if there are any questions that anybody has, feel free to ask.
Do you want to wrap things up?
Yes, thank you so much, Jerry. I really appreciate all that information. We will be, this was recorded, and so we will be putting that on our YouTube channel, and we will email that out to everyone that registered for this as well. So look for that email in the next 24 hours or so. And then again, if you have any questions, you can email us. In our email that we send out, we will also include Hunter and Jerry's contact information so that you guys have that and you can contact them with any questions.
And my email address is on the title slide. So feel free to email me if you have a question.
Awesome. Well, thank you so much, guys. And we appreciate all of the information that you shared today. Have a great day, everyone.